Okay, so on to the event, First Friday with Beth Cox. I'd like to commence with the acknowledgement of country. I acknowledge the Gadigal and Wangal people of the Eora Nation, from whose land this event is being broadcast today, and pay my respects to their elders past, present and emerging. I also acknowledge the traditional custodians of all the lands where you are joining us from today. And please feel free to make your own acknowledgement of country in the chat box if you would like to do so. Okay. Beth Cox has recently joined Authors Legal at the Australian Society of Authors and brings extensive experience in law and policy advising not-for-profits, government and commercial clients. She's also worked with businesses as an in-house counsel and public affairs advisor. Beth has led the intellectual property practice of a national law firm and is able to advise on both complex legal issues and the business aspects of commercial negotiations. She's held the position of director on numerous charitable boards and is a keen reader. Before becoming a lawyer, she completed an honours English degree and worked in a bookshop throughout, giving her an essential insight into the commercial or consumer side of the publishing industry. Beth, welcome to First Friday. Just if you can unmute.
Thanks. How's that? Can you hear me
That's
okay?
good. That's good.
Great. Thank you. Thanks for the welcome. I'm dialing in from Darkinjung land on the Central Coast. I'd like to acknowledge them and this beautiful place that I'm lucky enough to live in. Are you going to ask me a question or would you like me to jump in?
No, I'm going to ask you the first question is, do you miss the bookshop?
I was not a very good employee at that bookshop. I used to sit and read at the register, and then I'd be so surprised when someone wanted to buy something or needed some help. So I think they also made me a T-shirt about referring the most people to the information desk because I was, as always, a good referrer of questions. So I didn't know the answer, but I loved the access to the books.
Okay, very good. How did you move from commercial lawyer, contract lawyer, to a lawyer involved in arts and culture?
I've done a lot of different things. I've worked as a lawyer in a lot of different spaces, so commercial, also community law. I've worked for government in law reform policy and also as an in-house counsel. So this particular job at Authors Legal, I feel like it's a mix of all of those things because we're really involved in supporting the Australian Society of Authors, the ASA. Obviously, we're a wholly owned subsidiary of the ASA. So we provide kind of in-house support for operational things, but also for all their advocacy work, which is just so critical at the moment. And then we have clients, probably a third to a half of our work is advising clients one-on-one legal issues. That's very much like private practice. In fact, Authors Legal is set up as a law firm, just a really tiny one. We've got 2 part-time lawyers. So I run that tiny law firm. And then the other thing we do is provide general information to the public, whether or not you're a member of the ASA. And so in that way, I feel like it's like a community legal centre and not unlike the Arts Law Centre of Australia. It's just we have a really niche area.
Right.
So, yeah.
So you've sort of touched on it, but what would the typical day of a cultured solicitor such as yourself look like?
Well, we have general inquiries coming through. They can be about all aspects of intellectual property. Sometimes they're things like disputes which we can't help with. We don't have the resources, so we'll refer those. There might be inquiries about doing a legal read of a manuscript for defamation or that kind of thing. Again, we would refer that on or refer people to the information that's available at, again, the Arts Law Centre has amazing fact sheets and information on those sorts of things. But then the client work we typically do is reviewing and advising people on proposed publishing deals or deals with a literary agent. This is authors and illustrators before they've signed, which is obviously the best time to get legal advice, to help people try to get the best deal they can. And then sometimes people come to us when they have an agreement they've already entered into, but they're looking to leave that or revert their rights. or sometimes, move on from an agent, sign up with a different agent, that kind of thing. And then, as I said, there's the work with the ASA, which is always changing because the issues are always changing. And it's driven by member inquiries too.
Yes. The reverting of rights is an interesting one because I would imagine it's generally acknowledged that the landscape for publishing and writing in the last 5 years or so has been tumultuous, and across all different sorts of media. Mergers, acquisitions, conglomerations seem to be the order of the day, with larger institutions taking over smaller institutions. Um, what happens to authors and their work when a large publishing house takes over a small publishing house, or two small publishing houses perhaps merge? What happens to their works and their ongoing rights and possible future opportunities?
So often it'll depend on the terms of the contract. I think if there's nothing in particular in the contract about assignment of rights, which is when you can transfer your rights to another entity, then the basic sort of default position is that a publisher is able to, for example, if they're bought by another publisher, assign the rights they've got in their publishing agreement with you to the new publisher. But the ASA always recommends that authors and illustrators will negotiate, or sometimes it's there already, a provision that requires the creator's prior written consent to assignment, so that you can have the choice about whether you're happy for the new entity to continue to publish your work, for example.
If you're not, what are the general steps that you have to take?
If you don't have that in your contract,
Yes, yes.
I don't know that you would have that there's much you could do other than, I mean, there's always there's the legal situation, and then there's the situation in which, okay, I don't have a right under the contract, but I can still try writing a polite letter and ask for something regardless. And that's always worth a try. Same with reversion of rights, for example. If you might not meet the technical definition for out of print, for example, but you might want to revert your rights regardless. It's always worth asking in a really polite way, because often publishers or other parties will want to preserve a good relationship and a good reputation. So it doesn't hurt to ask.
Always, it's always polite to ask.
Mm.
Yes, yes. What about for new and emerging writers who are entering this landscape where there are increasingly fewer and larger publishers? And we've seen this not just in the publishing world, but also in the journal world. Journals are disappearing. Meanjin has been in the news recently. How does that affect them as they sort of go up and try and start to sign their first contracts?
I mean, it's tricky at the best of times being a new and emerging author, because the bargaining power is so limited. And then, as you say, these bigger entities sometimes have their standard contracts. They might be under direction from head office that might not even be based in Australia about what they will and won't agree to change in a contract. So that's always really tricky. Again, it doesn't hurt to ask, but you may well not get what you've asked for. We often recommend to our clients, we'll give them a written sort of commentary on the proposed agreement, but we'll suggest they pick the things that are of the most obviously importance to them, and try to bargain for those, because if you come with a laundry list of changes, it's probably likely that a publisher's not going to agree to them all. Some of the most important things we'll probably touch on in a minute, but there are some key things to ask for that are to do with the actual grant of rights you're giving, because once given, it's hard to claw back. So you can put some limits on what it is you're actually granting by way of copyright permission to the publisher.
Mm. What are some of the things that you see people coming in over your doorstep? What sort of issues are they raising with regards to the rights that have been assigned that they may not have realised they assigned, or they would now like to reassign?
I think a classic sort of problem is where there's an unclear or unfair sort of definition of what is out of print. So sometimes out of print can be if the work can be defined in the contract as if the work isn't available anywhere to buy. But if you have something that's available on print on demand, that might satisfy that requirement. So it's not, it could be not actually selling any copies at all, but it's available on print on demand. So therefore, it's not technically out of print, so you can't revert your rights. So we always encourage authors to ask for an out of print definition that, for example, might talk about number of copies sold, have a minimum number of copies sold in a particular accounting period, or have a minimum royalty revenue to the author in an accounting period, so that if it falls under that, you can then trigger the end of the contract if you like that.
Okay. When you are signing a deal, what do you think are the top three things that, as a new author, say as a new or emerging author, that you really need to be thinking about?
Pretty hard. I'm looking at we've got this new, I just have to plug very soon, the ASA will be releasing a new template model publishing agreement with some really clear and useful provisions and a new structure. So this new agreement is extracting all of the key points that can sometimes be hidden within words in a contract and put it up front in a 1 or 2 page just itemized list, which just makes it so much easier if you're not familiar with these publishing contracts, which can be very wordy. So there's the term of the agreement. Typically, publishers will ask for the life of copyright, the legal term of copyright, which is 20 years after the death of the creator. Sorry, 70 years after the death of the creator, which is a really long time. You're signing away your copyright, for the foreseeable future. So it can be hard to limit that term because it is a bit of a standard ask. But what you can do instead, as I mentioned before, is make sure that there's really clear reversion rights so that you can end the contract where sales aren't great. Equally, you can limit maybe the territory of the grant of copyright, so you can make it just Australia and New Zealand if the publisher's not used to selling overseas or doesn't have the contacts. And you might limit the format if that's appropriate. For example, if the publisher's not used to selling rights to produce audiobooks, then you might want to retain that. But it also depends, everything depends. It depends on your own situation and your contacts and whether you have an agent or other ways of selling those sorts of rights. But there's also the subsidiary or secondary rights. You may grant those, things like screen adaptations. You may choose to grant those to a publisher, but only with what we call a use it or lose it clause. So basically, within 2 years, if you haven't exploited those rights to the mutual benefit of both parties, then you might, then the publisher loses them, they revert to the author. So you can ask for all those sorts of ways of, you're still granting something, but you're putting a reasonable limit on the grant so that you can always take it back if it hasn't been utilised properly or to your satisfaction.
Yeah, and that sort of brings us back to that polite ask, doesn't it?
And it is, it does depend on people's circumstances. Some people are happy to grant everything. They have no other means of placing those rights. So it's a very personal decision.
Yes. Okay. When we were looking at bringing you into this, I sort of went searching through people and speaking to people about myths, about the true and false of publishing and copyright in Australia. So we're just going to go through a quick list, and so give us a true, false, and then explain your work. First, true or false? In Australia, you don't have to do anything to protect your copyright. It's automatic.
So, loyally, it's true in part. It is automatic when you create an original work. A single person or an identifiable person, and it's in a material form. But so there's no requirement to register or that sort of thing, your copyright. On the other hand, if someone infringes that copyright, you would have to take action to protect your copyright or pursue to stop the person infringing. So, and that's often, like, no one wants to go to court. That's often a really unlikely thing for people to do. So it's a tricky situation, and I don't want to preempt what we're going to talk about a bit later, but in the situation of copyrighted material, Australian creators' copyrighted material being stolen to, use overseas to train large language models in AI. That's an example of there's really not much you can do to protect your copyright there.
Yeah. So there is a difference between copyright being asserted and copyright being protected.
I would say, yeah.
Yeah. So if you're aware that someone is using your work and not attributing your name to it, or is getting monetary value from it, you have to take steps, don't you, to protect that? Otherwise, it can just continue, and it's like, well, you never stopped us.
Yes, and that's to be distinguished from moral rights, which is your right as a creator to be attributed as the creator of that work. That's always yours. Um, and it's even if, sorry, I'm confusing the issues a bit, but that is a right that you would never pass on to somebody else, whereas a grant of copyright, you can give someone permission to use your work, and whether or not they pay, or you could make it open Creative Commons license material. But yeah, I think I'll wrap up here before I tie myself in knots.
Oh, no, it's interesting. I wonder if you could just explain a little bit more about moral rights and how that difference is differentiated to copyright.
Yeah, so it's codified in statute, but it exists in different countries in different ways, depending on the jurisdiction. But the idea in Australia is that you have the right to be attributed the work as the author of the work, and for that work not to be treated in a derogatory fashion. But again, if somebody did infringe or breach those rights, I think you would still have to launch an action, or your publisher could on your behalf. Generally, publishing contracts will provide for a publisher to be able to, particularly in the case of infringing copyright, to bring an action in connection with you.
Yes, yes. And you're saying that they can't be traded away?
Yes, they're kind of essential rights that belong to the artist, the creator.
Okay, okay. Good, good, good. Okay, so another question, true, false. I'm writing a work of fiction based on fact, i.e., my life and some of my experiences. As long as I change the names of the people involved, I can't be sued for defamation.
That's not quite right. I think in general terms, defamation is about causing someone harm who's identifiable in something that you've published. So changing names might not mean that they're not identifiable. I think the best way to the best place to find information on this is the Arts Law Centre of Australia has some really great information sheets on defamation. And often if you're working with a publisher, they will instigate a legal review of your manuscript to make sure this doesn't happen, and it'll be at their cost. So that would be the best way to make sure you're fine in that respect.
Does it happen very often in this country? Authors of fiction being sued for defamation?
Oh, I think you're asking the wrong person. I mean, I would only know from reading the paper. There's so many high-profile defamation cases, but from memory, they're less about authors. The ones that spring to mind, and more journalism.
Yes, yeah. Yeah, no, we do see a fair bit about of work coming out of journalism, and as you said, that where defamation does play a role, but I can't remember like a work of fiction that comes through. There's things
Was
that,
it? Yeah,
yeah.
I'm just think that like years and years ago there was a Bob Ellis work that was pulped, but I can't remember the background.
Yes, yes, yes. Okay, so another thing, I can quote anything in my book, in my work, as long as I think it's fair use, i.e., song lyrics, poems, other works of fiction, or non-fiction.
Yeah, so in Australia, we have fair dealing in the Copyright Act, not fair use, and it is different from the American idea of fair use, which is more liberal in a sense. So in Australia, fair dealings, there are certain categories where you don't need to get permission to use copyrighted material, but it's things like research and study, or criticism and review, or news reporting. Um, so that's again an untrue statement that you've fed me. I think if people are interested in knowing more about it, the Australian Copyright Council has a free legal advice service on copyright queries, and also a lot of information on their website. So that would probably be the best place to turn.
Yeah. One author who is, I think, not notorious, but quite famous for using copyrighted material from other people, Stephen King, loves American songwriting. And
Mm-hmm.
every time he quotes a line, you can see there is an attribution that he's got
Mm-hmm.
permission to have even a single line of a song
Yeah,
going through his head.
he can afford it. Or maybe people are lining up to be in his books.
Just get me noticed, and then I'll get
Mm.
increased plays on Spotify. Something along those lines.
That's
Yeah.
right.
Yes. Okay. On a somewhat related thing, true or false, if I put something on the internet, I'm sort of agreeing that others can copy it.
So that's not true. It really just comes back to those general principles of copyrighted material. It doesn't matter whether it's online. If you own the copyright, you own the copyright. People need to ask permission to use it. Um, yeah, I think it's a shame, obviously, that in a digital form it's more easily infringed, but the same principles apply.
Yeah. When you place something on the internet, does it matter where the server is? What is a legal what's the legal jurisprudence area, if that's the right word, that is important?
I think this is a total guess. Doesn't come up in my everyday practice, but I would imagine it's where the act occurs. So um, where the infringing act occurs, the jurisdiction of the person who's taking the action or the company.
Right. So if you say are an author on a writer on Substack and someone is just taking your words and putting it up as their own blog or their own work, it's where that person is copying it that is most likely they're going to be the place.
I think so. And my basis for that is the Anthropic case where, that AI company based in America was using pirated materials, including Australian copyrighted material. Um, and I'm not sure that there's any redress for authors based in Australia because it happened in the overseas.
Right. Yes. Which I think gets us on to artificial intelligence. And artificial intelligence is something that appears to be on everyone's mind at the moment, especially in writing, and a justifiable fear that it's going to greatly impact even more the landscape of writing and publishing in this country. We're not going to spend a lot of time and go deep into AI in this because it's a broad topic and we don't have time. But I'm interested in your view on the Australian government stance on AI not being able to mine Australian works. Can that stand long term if it's not supported by legislation in other countries?
So there's different parts to the question. There's the the theft that's already happened offshore, and the ASA would argue is still happening because the models that were trained on that stolen copyrighted material are still in use, in existence, including in Australia. But um, there, that's to be separated from um, going forward how to regulate the way that um, there's a lot of issues that are components of that question. I think from the perspective of authors, writers, and illustrators, um, the best approach is to have explicit discussions with their publishers when negotiating agreements about the use of AI. And then you've asked about the government's stance. There are various schemes to try to compensate, in discussion to try to compensate authors. The general principles for approaching how AI is regulated that authors are seeking is a transparency about the use, what's been used and what's proposed to be used, seeking their consent to the use, and then compensation, obviously. And so we advise people, when you're looking to include provisions in your agreement about the use of AI, those are all the sorts of things that need to be discussed with your publisher, so that, most importantly, there can't be any interaction with AI without the author's consent. And then they need to know what's going to happen. There has to be transparency, and they need to be compensated if they do consent.
To it. So the government stance is in some aspects independent from the publisher. So the publisher can sign an agreement with an author to allow AI to use their work.
I think the government's saying they're not prepared to modify the Copyright Act to make a new exception to this asking for permission, which is a great stance to take. And then beyond that, the question is, how do people ask for permission? How do they organise payment where permission's granted? There have been a few different models proposed, but ultimately, I think it seems that a private arrangement's voluntary licensing between the creators and whoever wants to use their content are going to be the most lucrative solutions for creators.
Mm-hmm. Questions are coming in from the audience about this, and as I said, we don't want to spend too long on this in this particular talk, but if you find that your work has been replicated, so I suppose what we're talking about is like plagiarized by AI and it's coming up and somewhere else in a slightly different form, what are the legal avenues?
It depends, like I said, where it happened. If it's happened overseas, it's a very tricky situation to address. There was a class action, the Anthropic case, where some Australian authors were part of the class, if you like, and they may stand to gain some money in the settlement. But even without wanting to go into too much detail, even that class was narrowed by the fact that they required people to have registered for copyright in the US, which is a separate system different from Australia, where you register for copyright and it affects your entitlement to statutory damages. And a lot of Australian authors wouldn't have done that. So setting that aside, I think the ASA is always there to support authors if they've found anything of alarm. And same with Authors Legal, contact us. As I said, we don't engage in disputes work, but we can help you, support you, find somewhere to go, because that's obviously not an okay situation. If it's happened in Australia, then yes, you will have, there is action you can take.
Yes. And Nora also asks along this way that if it talks about having to formally copyright a work, but I think you've covered that. In Australia, there is no need to formally or register a copyright in any way.
No, it's automatic as soon as you create something in a material form. Sorry if I muddied the waters by talking about the US. It's also the same in the US. It's just that if you take the additional step in the US of registering, it makes it easier if there's a court case about it. That's all. But we don't have that system here.
Yes. So if it did go to court, you just have to be able to prove that you were the producer of the work.
Yes. Yeah.
By being like producing files or showing where it first appeared on the internet or anything along those lines. Yes. Yeah. Okay. Speaking of the internet, what has been, in your mind, the biggest change that the internet has forced upon writers in the publishing industry from a legal viewpoint?
This is, again, I'm not sure if I'm qualified to answer, because so much of what we advise people about is actual books or ebooks. I'm thinking there is the issue of we get it. We've had quite a lot of clients approach us recently with author-assisted or hybrid or contributory funding publishing agreements where they're paying money up front for a book, whether it's in print form or digital form, to be produced and then uploaded to online platforms for sale. But unfortunately, quite a lot of these agreements don't have really much marketing or distribution support. So I think there's sometimes an illusion that making something available online means that it's going to be discoverable and bought, when actually there's a lot of things available online. And of course, AI slot is not helping. There's more and more of the market's diluted. So I suppose these sorts of, for that reason, it's really good to understand exactly what it is anyone's promising you, particularly if you're paying, if you're funding the production of the book. How exactly are they going to support you to sell the book? Because, yeah, loading it to an online platform might not really have much effect if people don't know it's there and you don't have your own website, for example, or a way of promoting the book.
Yes, yes. What about if you've signed an agreement, and this is coming from Maliha, and you've got permissions and things that refer to only a couple of countries. So you can publish this book in Australia or the UK, and it's available maybe as a PDF online in both of those countries. How does that work in a time when you can use VPNs to pretend you're from any country in the world, and anyone then can pretend to be from wherever they want to be and download and purchase your book? Is that an issue?
I think it is. I think another issue we've seen is where people, they do want to revert their rights and terminate a contract, and then whoever was the facilitator of putting their books or making them available online using third-party platforms isn't actually able to effectively retract that book from sale from those third-party platforms for whatever reason. And so people can be really distressed because they think they've reverted their rights, but they're actually not able to stop these third parties who they didn't contract with themselves, so they don't have any legal relationship with, from continuing to sell their books. And where are the royalties going? We've had situations where, for example, the publisher's gone into administration, and it's a really tricky situation to try to get those third-party platforms to stop selling the book.
Because they were dealing with an entity that no longer exists.
Yes, yeah.
With the thing. Nora does on a similar piece. Deborah asks if people self-publish, and a lot of self-publishing is done through print on demand or through online at the start, they do retain 100% of their copyright. Is that correct?
Again, it depends on the terms of the agreement, but often yes, if you're paying for it and the publishing service provider will say, yep, you're not granting us copyright, we're just helping you produce the item. But there's a few technicalities there to do with, I think, the ISBN, whether it's one that can be is mobilised if you want to sell the book yourself, or whether it's dedicated to that particular service provider, which means if you're no longer working with them, it's no longer valid. Sorry, was there another part to the question?
Yes. If they retain 100% of their copyright, they can do with it what they want afterwards, can't they? As long as it's within the terms of the agreement. They may have signed an agreement that says they retain the copyright, but they agree not to do anything for 12 months.
Yeah, so I've seen all different variations of agreements. I've seen some that are sort of almost, very arm's length, and have said, we don't mind what you do with this whatsoever. You can enter into direct competition with us. You can go to another service provider and have a book produced exactly the same as we. And I think the more they say that, the more I think, does that mean you just have no vested interest in the final product you're making? I don't know. I do see it as a bit of a red flag sometimes. And again, it depends so much on the particular creator's ability to sell books themselves. If they've got a ready audience, if they've got a website, a blog, a podcast, a following, um, then that might be a really, it makes a lot of sense. They can sell the books via their own channels. But if not, it's going to be harder. And then there's the issue of, if you're hoping to one day get a contract with a traditional publisher, they wouldn't want to publish a work that's already been published.
Yeah.
So, but having said that, I've seen people who've done a kind of hybrid arrangement for their first book, and that's done well. And then they have been successful in getting a traditional publisher next. So sometimes it's a way of getting into the market. So it really depends a lot.
Yeah, and interestingly, you now see very large, successful authors such as Brandon Sanderson moving the other way, moving from traditional to almost into self-publishing,
Mm.
avoiding the
And
middle.
yeah, that I think if you have the wherewithal, and it's a bit like the negotiating your contract in the first place and which rights you wish to hold back. Because if you're a really sophisticated, established player, you can be very tight with what you grant because you've got all sorts of means of executing the best deal for you um, elsewhere. So it's very dependent on the particular person's circumstances.
Yes. Now, you've mentioned ASA and Authors Legal a couple of times. I wonder if you could just give our audience a really brief rundown of the typical things that both groups can help with.
So, well, Authors Legal is only a kind of new offshoot from the ASA. It used to be called the Contract Review Service, and it used to fit within the ASA, and the ASA itself has been around for years and years. The ASA has a member advice line. It does so many things. There's a team, I think, of 9 in the ASA, and then a lot of contractors offering manuscript assessments, publishing consultancies. They do literary speed dating, where they set you up with a publisher or an agent to try to be successful in getting those sorts of deals. They run events, they have awards, they do a lot of advocacy, and they do a lot of advocacy behind the scenes as well for the rights of creators. So they're just a really effective organisation driven by members. And then Waters Legal is this subsidiary, as I said. We will we give legal advice to our clients. Can be either members of the ASA or non-members. This is subsidised fee. Actually, the fee is subsidised regardless of whether you're a member or not, but there's a lower rate for non-members. Sorry, for members who come to get legal advice through us, and it's a fixed fee, so it's a one-off fee. It's not commercial rates at all. But yeah, I mean, I think I could go on forever about what the ASA does.
Yeah, and I think that as with all these things, and you've hinted at this, it's better to seek advice early, isn't it?
Absolutely. And it's I have to say, I'm the CEO of the ASA is frequently on the phone with members. It's an all hands on deck sort of enterprise, and people we're just absolutely there to support people, happy to help whichever way we can. And obviously, if we can't help ourselves, we'll find someone who can. So it's a great resource.
Yes, yes. One thing that I'd like to ask you is that in a previous life, I had the misfortune to have to seek the professional help of a lawyer or a solicitor with regards to work that I was doing, and I was in his office and I was ranting at him about the inequity of what he was giving me, and he just sort of looked over his glasses at me and he said, "Andrew, you keep talking about justice, but I practice law." Is there an issue in Australia where you think there is a gap between justice and law for Australian writers and Australian publishers?
Yeah, I do think this issue of the use of pirated materials in training AI is a clear sort of infringement of copyright that is very difficult to do anything about. That seems an absence of justice. But and obviously the law is jurisdictional, and we are in Australia, but we do live in a global world now. It just doesn't seem right that you can go to another country and do things that wouldn't be allowed here, but that's the way it works.
That's the way it works, which is sort of we've touched on with the fact that we are living in a global internet world, and
Mm,
there are people all over, all over this beautiful planet who can access the work that we do. We're going to
mm.
start getting into much more of the meat of the audience questions.
Yeah, great.
Please don't be shy. If you do have questions, please put them into the chat and we'll do our best to get to them. But one that follows on from that global and the fact that piracy or unfair use or outright stealing can take place anywhere across the globe. Carissa asks, is there a good time to register for copyright in the US? And how do you start?
Well, you would absolutely, I think we're recommending now, after this case, yes, do. If you think you're going to sell books in the US, register. You can ask your publisher to do it for you. It's often something you can build into the contract. But I think the US Authors Guild would be the best place to look for information, because they have a lot about, in particular, what's come out of that case, but just in general, really useful information about the US system. So that would be the best place.
Yes. And we're having a lot of questions about permissions and the legal risks with assigning rights. Are there
Mm.
any that you know of particular risks with, say, signing a film deal or a TV deal?
We don't do, I'd love to branch out into giving advice on screen rights, but at the moment we refer people to the Australian Writers Guild, who looks after screenwriters. Um, I think the only thing I'd say is that when you're looking at the original publishing agreement, those rights can be really lucrative. So if you think you can place them individually and separate from the publishing contract, then don't grant your publisher those subsidiary rights, because they are effectively acting as your agent when you do that. So they'll take a cut, but they haven't really done anything. um, I mean, you could argue that, but if you do give them those subsidiary rights of screen film adaptation and those sorts of things, you would want to take a high proportion for yourself. And the ASA's template has recommended royalty splits for those sorts of things.
Yeah. Are there particular risks? You were talking about moral right earlier, and the derogatory use of the product or of the work. Films are rarely 100%, if ever, faithful to the work. What right does a writer or an author have to stop the direction or the path a film is taking if those film rights have been assigned?
Yeah, that's a really interesting question. I don't know the answer to that, but I do know that that kind of concept of derogatory treatment of a work, it's pretty extreme in that sense. It's something that would be really offensive, and again, I'm straying outside my remit because I don't really give advice on moral rights, but I'm recalling what we learned decades ago when I was at uni, and it was more, a morphing of that original work into something completely unrecognizable and absolutely taking liberties with what the artist created. That makes sense.
Yes, yes. And we've got other issues here, such as translation. Specifically, Liz was talking about translation into Braille, but translation into many other languages.
Mm.
What issues does an author need to be aware of when assigning that? Because again, translation can also be a problem.
Yeah, and I think again the publisher might not have. We're just always approaching it from is this particular publisher, do they have experience in placing translation rights? Because again, they would be acting as your agent in any kind of deal like that, and are they the appropriate party to be giving that power to, or is it better to go directly to someone more experienced? And do you have contacts, or does your agent have contacts overseas? You might want to make a direct deal with them instead. So, I'm thinking more of the commercial ramifications rather than I can't think of any specific legal risks.
Right. Yes. There's and it's something that we talk about a lot with our members and people who come to us for advice. There's a lot of homework to be done by someone who's entering into an agreement, isn't there?
There is, but I do, just to plug our service, I do think that's the beauty of you. The fee for members is basically $500. You can give us a contract that I have to say, I've been a lawyer in lots of different fields, but until I started looking at these publishing agreements with Authors Legal and agency agreements to a lesser degree, I wouldn't have appreciated half of the import of what was in them until I looked at the amazing library of resources that Authors Legal has, and did the handover with Victoria, who was there before me, and it's just they're very specific, very niche issues. Often, the agreements that come to us, even where we're commenting on the terms, but we're also saying you should really ask to insert these extra provisions because they'll help you if you want to, for example, if you have an issue about whether you're being paid royalties correctly, you want to be able to inspect the publisher's accounts, or, relatively minor thing. Well, not minor, but, they seem minor, but they can save you so much angst in the long run. And I do think it's a situation where you're potentially signing your rights away forever. There aren't that many agreements that are comparable to that. So you want to have a clear way to exit the agreement if possible, if you need to. And sometimes that might be not relying on the out of print clause. It might just be a termination for convenience clause you might want to add. And you certainly want to understand what you're promising as well, including the warranties and indemnities, because it's very unlikely, but you could be sued. You want those explained to you if it's not obvious.
Yeah, and I think to us it makes sense that given the amount of time and effort and their self that authors pour into their work,
Mm,
that it makes sense to not rush into agreements,
yes.
not just sign the first thing that's put across your desk, but to
Mm,
actually go, no, I worked on this book for 2 years and it's been through
mm,
17 drafts. Maybe I can take time with this agreement.
mm. Absolutely. And I think even where, for example, you feel you don't have a lot of bargaining power, it is powerful to have the information about what you're agreeing to, and then maybe for your next work you have a bit more bargaining power and you can build once you have that understanding. And I haven't even talked about there are other things like options clauses. You might not want to show your next work to the publisher. You might, there's a lot of different seemingly innocuous provisions that can dictate your future um, steps, even, quite a long way down the track. So it's definitely worth reviewing it really carefully.
Hmm. What sort of issues might arise with an options clause?
So that's where publishers might say, you'll give us the first look at your next work, and we'll decide whether we want to publish it. But you don't have to agree to that. And if you're happy with your publisher, you might do that anyway, but it's best not to have it in the contract in case you're not happy and you would like to go elsewhere. And sometimes those clauses might not have, for example, a time limit. So even if you're happy to show your publisher to give them the first option, you certainly want to insert a deadline so that they have a reasonable time to think about it, but then they need to get back to you so that you can move along to someone else, and those sorts of things. Just little details, but important to have in there.
There is a lot to think about, which is even more reason for people to take their time with it.
Yes.
Um,
Yeah.
there's a lot of questions coming through. So Feng has asked about writing a book based on a real legal case or on real life. That seems to be something that you would really need specific advice on, isn't it?
Yeah, and again, if you're working with a publisher, then they would be there to help you and support you with that kind of legal review of the book. Otherwise, you can engage commercial lawyers for a legal read, but it's pretty expensive. Um, Yeah.
What happens in a legal read? What would you expect to come back? You give your work and say to a
Yeah.
solicitor, say, look, this is based on some real life situations.
Mm.
Legal read. What would typically come back to the author?
Yeah, I'm sorry, I don't know because I've never been involved in that process, but it's a really interesting question because actually there was an academic who approached the ASA, but she was writing a PhD, I think, on censorship via a legal read, like a preemptive censorship, because in her view, you know, publishers were arguably getting more conservative, and she was doing a special study on that, which was an interesting way of thinking about it. But other than that, I haven't experienced that myself, so I don't know. Sorry.
No,
I
no,
mean,
no.
obviously they'd be looking out for defamation concerns, but other things too.
Speaking of defamation, something that occurred in a TV show that I was watching, because I get all of
Mm.
my legal advice from television shows most of the time. Can you defame a dead person?
I'm not a defamation lawyer. um, so I don't know, but I'm sure there's some legal action that could be taken.
Perhaps by their
Estate.
offspring, yeah, or an
Yeah.
estate if it's bringing them into disrepute.
Mm.
Okay. Well, that is fabulous. I mean, the law and writing and publishing is such a huge field.
Mm.
There's so much that we could get into. But thank
Yes,
you very much for the time that you've given us today.
that's a pleasure.
Before we go, if there's any other last questions coming through from the audience, put them in. But usually what we do is we finish with a very simple question, which is, what are you reading now, Beth?
Well, one more plug for the model template that's going to come out. That's
Yeah.
great reading. But I've just started the Lena Dunham memoir, Fame Sick, which I think is going to be a bit wild.
Yeah.
But we'll see how that goes. I'm looking forward to it. And one other thing I wanted to say is that we're running a seminar on understanding and negotiating your publishing agreement on the 20th of May. That's through the ASA. An online webinar that will go, I mean, it'll cover in a bit more detail what we've talked about today. So I wanted to say that.
Okay, good. So if this has whetted your appetite, that's something that we would certainly encourage people to go and look at.
Yeah,
Beth, thank you very much
no,
for your time today. It's been
pleasure.
an absolute pleasure. Thank you for everyone who's joined us today, and to the Writing New South Wales team, Annabelle and Anna, who have been working behind the scenes, putting questions into the chat and putting links into the chat as well. We couldn't do events like this without them. And of course, to you, the audience, for your questions and your engagement. It's great to see so many of you online joining us for these chats. Look, if you're not already subscribed to Newsbite, that's our weekly email newsletter. Please do so, because that lets you know everything about what we're doing in events such as this, as well as all of the workshops and other services that we provide for writers across the state of New South Wales. So please do so. You can find all that information on our website. So again, thank you, Beth, very much. And we'll say goodbye, and we'll hope to see everyone back for our next First Friday. Thank you.
Thanks, everybody. Hope it was useful. Thanks. See you.